we are here to talk about some very important improvements to the Live-in Caregiver program. Let me first of all say, some people would like to end the Live-in Caregiver program. Some people I don't think fully appreciate the value, the hard work, the centrally important jobs that are done by caregivers, usually women of great compassion, who give of themselves. Many of them have training as medical practitioners, as nurse assistants, as nurses, and people who come from different backgrounds, many if not, in fact, the vast majority originally from Philippines. And these are people who come to Canada to help families who need support, taking care of the disabled, taking care of elderly, family relatives, taking care of children. This, as we have an aging population, is a program that will continue to grow because we will see more and more families who need to take care of seniors who, because of their own family structure, are unable to do so by themselves. And so Canada benefits hugely. Canada wins with the support and the help of the caregivers. And I want to start by saying this very important thing. We honor the commitment and the hard work, the dedication, and the sacrifice of the caregivers. And we are proud to have a program that allows them a pathway, a privileged pathway to permanent residency in Canada, where they can sponsor in their families and have a bright future in this country. A pathway that might not otherwise be available to them through other permanent resident streams of immigration to Canada. So I think the objective of the program is a good one. It helps Canada fulfill its caretaking needs, and it provides new opportunities for those who come through the program. But so we don't want to end the program, as some would have us do, but we need to mend the program. We need to improve it. We need to fix it, because we have heard the tragic stories, the stories that June just told us about, most notably about Juana Tejada and the other caregivers who found themselves caught up in the red tape of the second medical when they were facing the pressure of their own personal medical emergencies. We've heard about the tragedies of women faced with abusive employers, are unable, people who arrive and they aren't able to get, they're at the job that was offered to them doesn't exist. We've heard about women who have been exploited by unscrupulous consultants or agents who took money from them for jobs that didn't exist, or employers that made them work against the rules of our labor market codes. We have heard the pleas of these women to ask for fair treatment. They are willing to work hard. They're willing to help the families. They want the chance to be able to sponsor in their own families in due course. They appreciate and benefit from the program, but they want to make sure that the abuses that have occurred, that we put an end to those abuses. And I want first of all to pay honor, as June has done, to the advocates in the caregiver community, the Filipino community, and other organizations that have given a voice to the voiceless, that have stood up for those who really don't have any political power in Canada, those who don't have really much economic sway, but who have been a strong, united voice. And that's the reason I'm standing here today. When I became Minister of Immigration a year ago, I began to become aware of the many problems in the Live-in Caregiver program. And that's why in the spring I launched our series of consultations across the country. We had roundtables here in Toronto, in Vancouver, in Winnipeg, in Montreal. I had conference calls. We received written submissions from hundreds of individuals. And we tried to take a balanced perspective in the advice that we got. We heard from caregivers directly, from their advocates, from people in the settlement organizations, from people in the churches who help them. Sister, good to see you. We heard from lawyers and from consultants. We also did listen to people representing the agencies and as well, because we wanted to get all of the perspectives and make sure any changes we make are balanced and responsible. And so, as a result of those consultations, I had to study closely the different ideas that were put on the table. Let me also say, we commend the provincial governments for moving in the right direction. Yesterday, we celebrated an important victory with the passage of the new law through the Ontario legislature that will complement the changes that I'm about to announce right now. So the Live-in Caregiver program of course, is a component of the Temporary Foreign Worker Program and assists employers in recruiting caregivers to live and work in the homes of those for whom they are caring in order to provide childcare or support for seniors and people with disabilities. The program facilitates the entry of qualified caregivers into Canada when there is a shortage of Canadians or permanent residents to fill those positions. In return, the program allows live-in caregivers to apply for permanent residence in Canada after working for 2 years within the first 3 years of entry into Canada to work in the program. But as I've said, there are concerns, and we need to address those concerns to empower the caregivers, to ensure that they are not subject to abusive situations, to ensure they are not exploited by unscrupulous consultants, and to ensure that they have a fair, clear pathway to permanent residency. That's why I'm here to announce that the Government of Canada is proposing measures that would make it easier for live-in caregivers to obtain permanent residence, to make the program more flexible for caregivers, and to better protect their rights. C'est la raison pour laquelle je suis ici aujourd'hui. Le gouvernement du Canada propose des mesures pour aider les aides familiaux résidents à obtenir le statut de résident permanent, ainsi que pour simplifier le programme. Under these planned changes, our government hopes to honor the memory of the late Juana Tejada by eliminating the requirement that all live-in caregivers undergo a second medical examination. And so effective the date of the implementation of these regulations in about 30 days from now, the second medical will be waived for all caregivers entering the program. And in this, we honor the memory of Juana, of Celia, and all the others who have been brave champions of their sisters, the Filipinas, and the others in the caregiver program. In addition, the period allowed to gain the required work experience to apply for permanent residence will be extended from 3 years to 4 years. This responds to concerns that some live-in caregivers are not able to meet the requirement within 3 years and would allow for unseen breaks in employment due to events such as pregnancies, illnesses, or loss of employment when people need to find a new employer. The changes also include a measure whereby live-in caregivers who work overtime could apply for permanent residency even faster than now. Once the changes are implemented, caregivers will be eligible to apply for permanent residence after 3,900 work hours. The equivalent of a standard work week over 2 years. Because the work could be calculated in hours, some of their overtime hours could count toward this requirement and would allow some caregivers to apply for permanent residence sooner than is now the case. Furthermore, a number of additional changes that we are making will increase the protection of live-in caregivers and improve their working conditions. Par ailleurs, un certain nombre de modifications supplémentaires permettront de protéger davantage les aides familiaux résidents ainsi que d'améliorer leurs conditions de travail. Under additional improvements to the program, employers of live-in caregivers will be required by the federal government, working with the provinces, to pay travel costs, medical insurance, workplace safety insurance, and any recruiting fees owed to third parties. No longer will caregivers be paying people to get the jobs to work hard for them. This will complement new legislation passed earlier this week in Ontario, as I mentioned, which imposes fines of up to $50,000 and a year in jail to anyone who charges a placement or recruitment fee to a caregiver in the province. And let me say that also complements the provision in the Immigration Refugee Protection Act of a $50,000 fine, up to $50,000 fine for any employer who forces someone to do work that they do not, that is outside the parameters of their work permit, and that is not going to be tolerated.